The standard of proof is the immune system of family law. Courts keep suppressing it. In most Utah family law disputes, the governing standard is preponderance of the evidence. That means that the party seeking relief must persuade the court that the claim is more likely true than not. The standard is not a phrase to recite in an order. It is a decision rule for uncertainty. It tells the court what to do when the evidence is close, incomplete, or evenly balanced. If the evidence is in equipoise 50-50, the moving party loses. A tie is not a reason to compromise. It is a failure of proof. Family courts often bypass that rule in two opposite ways. The first is partial relief on an unproven allegation. One parent alleges abuse. The evidence is a coin flip. The court cannot find the allegation proved, but orders supervised parent time out of an abundance of caution. That may sound moderate, but it is not. It gives relief to the party who failed to carry the burden and treats the accusation as half-proved. The law has no category called half-proved. Concern is not evidence, and caution cannot replace persuasion. The second error is demanding corroboration where the law does not require it. A court may hear one witness accuse and another deny, then refuse relief because it is merely one person's word against another's. But testimony is evidence. If the court finds one witness more credible, that testimony alone can satisfy the burden. The court's job is to decide credibility and not to invent corroboration rule. These two errors share the same root. The fact finder avoids deciding, splitting the difference avoids deciding, demanding extra proof avoids deciding, but the burden of proof exists precisely to make non-decision impossible. If the court is persuaded, it grants relief. If the court is not persuaded, it denies relief. Honest enforcement of the standard also changes litigation incentives. Some parties file dramatic motions not because they expect them to prove, but because the filing itself creates leverage, delay, expense, or temporary status quo. Courts already have tools to address that conduct, including the shifting and sanctions of claims asserted without evidentiary support or in bad faith. The difficult case is the genuine victim whose truthful testimony cannot be corroborated. That person should not be punished merely because the case is uncertain. Truthful testimony is evidence, and uncertain case is not a baseless case. But courts do not do favors by granting partial restrictions on suspicion. That approach teaches the system to treat every claim true or false as half true. The better rule requires no new statute, no relief without persuasion, complete denial at equipoise, and meaningful consequences for filings pursued for leverage rather than proof. The standard of proof is not an obstacle standing between the court and justice. It is a mechanism that makes justice possible. It is family law's immune system, and it works only when the courts stop suppressing it.